Number two, you can have estate planning documents in place that will avoid the necessity of you having to spend all of your assets on long-term care costs. Long-term care costs are probably the number one threat to anyone's financial security. Long-term care costs range from being in an adult family home that might cost $3,000, $4,000, $5,000 a month, to an assisted living, memory care, $6,000, $7,000 a month, to a nursing home of $10,000 to $12,000 per month plus. It doesn't take a whole lot of calculations to see that if you are facing long-term care costs of that magnitude, your savings might go away really quickly. And when I say savings, when I'm talking about your long-term care costs, I'm also talking about, let's say you're married. Maybe it's not you, but it's your spouse that needs to go into memory care or other type of care facility. How are you going to afford to pay for that? Most people do what I call the uninformed thing to do, and they spend down their money. They simply use their income, they use their life savings, and they spend their money. And they spend their money, and usually it's on the first spouse. Maybe the first spouse gets pretty good care because the couple used all of their money to take care of the first spouse, leaving the second spouse or surviving spouse with absolutely nothing. That is not necessary. Now, as an elder law attorney at Elder Law Group, we have expertise in Medicaid planning. And because of that, we know what type of legal documents must be in place to allow our clients to use government benefits to pay for their long-term care and not have to spend down their money. And we have other videos on this, but what I want to talk about is what sort of estate planning tool or tools do you need in place so that you don't become impoverished through long-term care costs, the number one threat to financial security. The primary tool that you need in place during your lifetime, again, is that durable power of attorney, the durable power of attorney for finances. So I've already explained what this document does. This document grants authority to somebody else to manage your affairs when you can't. So let's say you're either a single person or you're a married person. And let's say you're a single person and you are facing long-term care costs. You will want to grant authority to your decision maker, they're called your attorney in fact, to be able to take whatever actions that you would want to have taken to avoid spending down all your money. The durable powers of attorney that are prepared by an elder law attorney are different than those of an estate planning lawyer who doesn't know Medicaid. So for example, in our durable powers of attorney as elder law firm, what we will do is we will grant authority to do gifting that might actually impose a period of ineligibility under Medicaid's rules. An estate planning lawyer likely won't do that. They'll likely limit gifting to the annual exclusion amount of $16,000 under the federal tax code. I'm not talking about the tax code. Tax code right now is not what I'm worried about. I'm worried about Medicaid's rules. I'm worried about making sure your money doesn't all get spent down on long-term care costs. As a Medicaid planning lawyer, I know strategies that will allow you to gift money and preserve assets, potentially 50%, 75% of your estate. It all depends on what your situation is. But if I, as an attorney, am working with a client who's had a durable power of attorney prepared by somebody who doesn't know Medicaid, there might not be the grants of authority in there that are necessary to do a Medicaid plan. And as a result, our hands are pretty much tied and we're not able to do the Medicaid planning that would be the optimal planning and save the most money. So the durable power of attorney and the authority contained in it is a critical piece to allow us to preserve assets for our clients. I was just talking about a single person. Let me talk about a married couple. So if you're part of a married couple and you're saying, Lynn is telling me I need durable powers of attorney to keep the court out of my business and to protect money against Spenddown from long-term care costs, you might be confused. You might say, I live in Washington or I live in Idaho, and this is community property jurisdictions here. And, my spouse and I, we can make decisions for each other. Wrong. No, you can't. You think you can because it's a community property jurisdiction. So let me give you an example. Have you ever tried to call on your spouse's credit card and they said, I'm sorry, we can't talk to you. Can you put your spouse on the line and they'll give authority? I have. So has my husband. Have you ever been in a situation where you've tried to sell your home? Let's say the home is titled in your name and your spouse's name. And what's happened is your spouse now has lost capacity. They've suffered a stroke. They can't sign anymore. They're no longer able to comprehend things. Without a durable power of attorney, you can't sell your house. Even though your name's on the title and so is your spouse's name, it's community property, you can't sell your house. If you don't have a durable power of attorney, your spouse will be who's lost capacity under a court-ordered guardianship, and the court will give you authority to sell that house. Very frustrating. You think you can do it because it's community property, both your names are on it. Sorry, your spouse has lost legal capacity. They don't have a durable power of attorney. They're under a court-ordered guardianship. So don't think just because you're married, you don't need a durable power of attorney. You absolutely do need a durable power of attorney. How do we use a durable power of attorney to protect assets for spouses when you're both alive? Well, Medicaid has some rules that say that if one of the spouses needs long-term care, they can keep between $60,000 and about $135,000 accountable resources. That's it. There are a lot of excellent planning strategies for a married couple. One of them is called a Medicaid compliant annuity. If that couple has too much money, more than that standard, Medicaid allows the couple to take that extra money and buy a Medicaid compliant annuity. Let's say they have $200,000 too much. Not a problem from a Medicaid planning perspective. We will take that extra $200,000. We must put it in to the name of the well spouse. We must use the authority under the durable power of attorney, assuming ill spouse lacks capacity, to take all the assets, put them in the name of the well spouse, do a separate property agreement. How are we able to do that? If it wasn't done before the ill spouse lost capacity, we can do it through durable powers of attorney that we as elder law attorney draft and provide for our clients, because we know that these are the things that are needed to protect assets. So a couple who has worked with an elder law attorney is going to be able to keep perhaps not all their assets, but a significant amount of their assets, perhaps all their assets. It all depends on what their situation is. Well, what I'm saying is we can keep those assets. We can avoid Spenddown for that married couple, not just because we understand what the rules are, but because that couple has the right durable power of attorney in place that gives authority to do a separate property agreement, that has authority to revoke any prior community property agreement, that gives authority to transfer all assets, transfer the house to the well spouse. And by doing that, this couple can avail themselves of state benefits to pay for that long-term care without having to spend down their assets. Also, having these durable powers of attorney in place not only allows us to qualify the ill spouse for Medicaid without a spend down, but also allows us to avoid the state's lien. In the past, what I've talked about is sometimes maybe the couple is already within resource limits, and so the helpful nursing home does a Medicaid application. That's a big problem, even if the benefits are granted. Why is it a big problem? Because the nursing home doesn't know how to avoid state liens. What has to happen, as I mentioned before, is the separate property agreement, the deed from the ill spouse to the well spouse, putting that property only in the name of the well spouse. Why? Because if the ill spouse is on Medicaid and on their death, any assets in their name will be subject to the state's lien. That's not going to be avoided if the nursing home did the Medicaid application and the couple didn't see an elder law attorney after that to fix it. With an elder law attorney, we are going to make sure that the state's lien is avoided by putting all assets in the name of the well spouse's name right when that ill spouse goes on to Medicaid. That way you can avoid the loss of the home or loss of any other assets that the state can get their hands on. So the two tools or the two ways to protect your assets I've talked about so far both involve durable powers of attorney. The first to avoid a court-ordered guardianship or conservatorship. Second, to avoid spend-down. These are all accomplished through having a very good durable power of attorney in place prepared by an elder law attorney. Now, to back up a little bit, I mentioned that I'm in the state of Washington and Idaho. So if you're listening from another jurisdiction, please make sure you talk to an elder law attorney where you live in your state, because there are going to be different rules, different provisions the powers of attorney should have. If you're out of state and you're listening to this, I would recommend finding an elder law attorney in your state. You can go to the National Academy of Elder Law Attorneys.org. That's NAELA.org, NAELA.org. And there is an option to type in where are you located, where's your loved one located, and find an elder law attorney in your jurisdiction. Because I would be doing a disservice to you if you're listening from outside of the state of Washington or Idaho, and if you thought what I am telling you is 100% true for your state, because likely it is not. I also want to give you that caution because, like I mentioned earlier, let's say you're listening to somebody else. They have really good videos on YouTube, and they're really giving you a lot of good information on estate planning and elder law attorney, and that's fantastic. I'm glad that there are other attorneys helping to educate, because that's really what we want to see as estate planning and elder law attorneys. But if they are in a different jurisdiction, keep in mind that what they are saying might be completely wrong for where you live. So for example, and this is getting us to our third tool to protect assets.